It's official. Both a husband and wife are going to be spending years in prison after they killed an 8-year-old girl by forcing her to jump on a trampoline in 110-degree heat. It is truly a heartbreaking case, and we're going to get into what happened, what the evidence and testimony at trial revealed, and the surprising deal the husband took. Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. Heading over now to Odessa, Texas, where we have another disturbing case of child abuse, but this is an extra layer of sinister because 48-year-old Daniel Schwartz just admitted that he forced his young adopted daughter to jump on a trampoline in 110-degree heat as a form of punishment back on August 29th, 2020. And this ended with her dying. 8-year-old Jaylin Schwartz, reportedly described in her obituary as full of life, loved horseback riding, ice skating, all things outdoors, that she loved all people and animals and was very interested in history and science. But sadly, she is not going to get to grow up because of what happened here. And Daniel has just pled guilty to manslaughter and was sentenced to 18 years in prison. But he wasn't alone. In a statement from the Ector County District Attorney, quote, investigators later discovered that Daniel and his wife Ashley had forced their daughter to jump on a trampoline for an extended period without food or water as a form of punishment. The trampoline's surface temperature was approximately 110 degrees at the time. People magazine also reporting that the ground so hot was approximately 150 degrees. This is according to police. Just imagine that heat, okay? Now, the autopsy revealed that Jaylin died from dehydration and hyperthermia, and the manner of death was ruled a homicide. But you got to go back to Ashley Schwartz here because she was previously convicted of capital murder back on May 1st, 2023, sentenced to 3 life terms in prison without the possibility of parole. And her trial was very interesting, possibly why he decided to take a deal. We're going to get into that. And by the way, we looked up this couple on TruthFinder, the powerful background checker that we use to help research our stories. Ashley Schwartz, she shows up under her parent maiden name, Ashley Lovelace, and the criminal history section shows her arrest in 2020 for capital murder of a person under 10 years old. And yes, Law&Crime, we partner with TruthFinder. We use it to get details on people involved in our stories. But even if you don't work in true crime, this can be an excellent resource to give you some peace of mind. After all, it's one of the largest public record search services in the United States. And with a paid subscription service, you can get access to unlimited reports about almost anyone. So right now, if you're interested, you can get 50% off of your first month of confidential background reports. Just go to truthfinder.com/LC Sidebar. Okay, back to this. So Ashley and Daniel Schwartz, they weren't Jaylin's parents. They were her guardians, according to reporting like CBS 7. And I'm going to talk more about what her biological mother had to say. But first, I want to bring on criminal defense attorney, former prosecutor, Florina Altshiler, to talk more about this. Florina, thanks so much for coming on. I know this is a tough case to talk about. I do have to ask you, though, right at the beginning, your reaction to the manslaughter charge, him pleading guilty to that, 18 years in prison. Let's start there. And also your reaction just to the way this little girl died. I mean, that is quite the headline.
It seems to me like this is clearly torture. We can never really be inside somebody's mind, but based on the facts and the evidence, we can make an educated guess as to what they were thinking. And common sense tells us that you should know better than forcing your child to jump on a trampoline in that weather, denying them food, denying them water, and forcing them to just continue and continue and continue would suggest that it would lead to death. It doesn't take rocket science. This isn't a shock. It's not a surprise. This isn't some accident. Generally, the district attorney's office could charge someone with murder and then give them an offer to a one-step reduction to a manslaughter. So that is not uncommon. And here he pled guilty to manslaughter with a pretty significant manslaughter sentence of 18 years. I've seen murderers get those double-digit numbers when convicted of murder. Often 20 years, sometimes 25, but 18 is not that far below.
Can I touch upon that for a little bit? Because it's my understanding he was originally facing also a capital murder charge and 2 injury to a child counts, pleads guilty to manslaughter. When you look at the law, 2 different things, right? So, and we're going to get into her trial, and I'm curious whether or not that had an effect on him agreeing to take this deal and whether it was offered. But remember, manslaughter is recklessness. Murder is intentionally or knowingly, causing the death of this young girl. From what I read, and based on the theory of the case, would it seem to suggest that Ashley, was more responsible, and he what? Turned a blind eye and just didn't do what he had to do? Again, the fact that he was initially charged with murder for her death to be offered and given manslaughter, I just want to try to make sense of that.
So he doesn't have to necessarily be the cause of her death intentionally if he's somehow participating or is present for it and knows and doesn't stop it. Under the conspiracy theory, right, one person can pull the trigger and kill somebody. The getaway driver is going to be equally responsible for that murder without pulling the trigger, without necessarily even being inside the premise. Just driving the other person away, they will be responsible for the murder. So is he as responsible as her, in my opinion? Absolutely, because common sense is he could have stopped it at any moment and didn't. And so he facilitated this just the same way as she did, and this is clear common sense. So a murder charge would have been appropriate, but it would be tough to prove. It's not black and white like where someone pulls a trigger on a gun. What did they mean to cause? Death, obviously.
Right.
Here, maybe he intended to cause serious injury to her, but not death. Maybe he intended to inflict punishment, but not to the point where she dies.
See, but the thing is, my understanding based on the reporting is he sat through his wife's trial and she was convicted of murder. And here's what I want to do. I want to go through different parts of this trial. And as we go through it, let's keep the question open. When looking at this trial, did it make sense that he ultimately pled guilty, that he realized he might not have had a great defense, and this is why he ultimately pled guilty and was accepted for manslaughter? So, by the way, according to CBS 7, he has already served 313 days in prison, so those days will count towards his 18-year sentence, just to keep that in mind. But I want to talk now about Ashley Schwartz's trial, because more was revealed. Now, according to OA Online and CBS 7, one of the big moments at this trial was when Jaylin's sister testified. And that actually marked 3 years since this girl saw Ashley Schwartz. And she testified that the morning in question started normally. They played with toys, they ate breakfast, but then later is when Ashley forced the children outside to jump on the trampoline as a form of punishment, to jump until she told them they could come back into the house. And apparently, by the way, this wasn't a one-time thing. According to this sister, the trampoline was used as a punishment before, along with spankings, carrying weights, writing sentences, picking up dog feces with her bare hands. Even Jaylin had her head shaved at one point. Now, by the way, I'm also not revealing the name of the sister. Some outlets are, some aren't. We're not going to reveal her name at this point. But on the day in question, in that scorching heat, Jaylin's sister explained that they may have drank some water, but it wasn't a lot, and that they were jumping for maybe 3 hours, and that it's possible they could have tried to drink from the dog's water bowls as long as they weren't caught. That's according to the sister. And although it was reported that witnesses testified that they didn't find any cups or water bottles in the backyard, that there were no pictures that documented any of these sources of water. So again, further proving that there was a lack of water for the girls. And Jaylin's sister even testified that the door to the home was locked, but she was eventually let back in once she finished her required punishment, her required amount of jumping. But apparently, this sister testified that the last thing she said to Jaylin was, quote, "The sooner you jump, the sooner you can come in for water." And we all know how all that turned out. Now, apparently, on cross-examination by Ashley Schwartz's defense counsel, they tried to reverse the narrative, showing pictures of Ashley and the girls over time, perhaps to show fond memories together, emphasizing that the girls were able to pick their rooms, the themes to their rooms, that maybe some acts were not really punishment per se, like writing sentences down was really for school and improving their handwriting rather than a form of punishment, that the carrying weights was during aerobic exercises, and also whether it was fun for her and her sister to jump on the trampoline. Now, Florina, you didn't have, I didn't have the opportunity to watch the trial in real time. I imagine you didn't either, but you could see what the defense was trying to do. Why wasn't it enough?
You can explain things away, but eventually it just adds up, right? Okay, so the weights were exercise, fine. Okay, so the handwriting were school related, okay, fine. But what about this? What about that? What about this? Eventually, it appears like it is a course of conduct intended to inflict torture. Eventually, there's just some that you cannot explain away. It does not make sense. And added together, compounded, and having the sister testify really changes things. And I think having the sister testify also adds a level of sympathy and adds an insight that we don't have to guess at, because she knows why her parents did this. They clearly told them why they did this. And it is just common sense, not an appropriate way to parent. And it's not a poor choice, but it's a consistent choice to inflict punishment in a way that's torturous. That becomes criminal.
And look, I mean, we say parents, they're guardians here, right? This idea that they inflicted this, it's even more disturbing when you think about where the blame lies, because Jaylin's sister, very compelling testimony, testified that Daniel didn't even give them more water or even check on them. So it goes to this idea about why he ultimately pled guilty to manslaughter, this recklessness standard. But here's the thing too, and I want to bring this up. So Jaylin's sister also apparently testified that Daniel carried her sister inside the house. Ashley called 911. She didn't know Jaylin, her sister, died until later on. But there is other important testimony that came out during this trial. So according also to OA Online, Ashley Schwartz took the stand too. The defendant apparently was the first witness for the defense. And she reportedly testified that the girls were spanked here and there, but they were only paddled once. That jumping on the trampoline wasn't a form of punishment, but merely she told the girls to go play outside because they'd been inside for too long. And it was interesting because she testified that she wasn't punishing the girls on the day that Jaylin died, but it's possible the girls maybe could have thought that. And then she tried to explain away other things, like the girls were carrying weights not as a form of punishment, but they were doing it on their own when they were watching Ashley working out and they wanted to join her. That she didn't force the girls to pick up dog feces barehanded, but Jaylin's sister did that on her own. Now, Florina, you do have to wonder if that could have worked, right? Obviously, it's the defendant's choice to take the stand, and I wonder if the thought was, listen, parents, they discipline their kids. Perhaps the jury would understand. Accidents like this happen. You could see the strategy for her wanting to take the stand here.
Of course, but clearly the jury has spoken. They heard her and they did not believe her. Perhaps a different jury would have believed her. Perhaps if she was a different person with the same story, it would have been believed. But clearly in these circumstances, they found her not to be credible. They said, we hear what you're saying, we don't believe it, and you are guilty. Had they believed her explanations, they would have found her not guilty. But I think cumulatively, the explanations are too little, too late, and too convenient. Of course, she's explaining it this way now. What else is she going to say? But common sense, right? Okay, you didn't want to kill her, but you left her out there for 3 hours and locked the door and didn't let her back in.
So let me just tell you what she said about the day in question, and I'll throw it back to you. She reportedly testified that she did make the girls breakfast. She knows the girls had water bottles because they were taken out of the fridge, that they even came back in to refill the water, that a window was open for them to come in, that she didn't lock the door, that it was Jaylin who wanted to keep going back outside despite the heat, and she did check on her while she was playing. And her defense attorney also suggested the girls would have had the ability to turn on the spigot from the hose if they were really thirsty, and that they brought water bottles back into the house because they were afraid the dogs would get to them. This is all according to OA Online. But Florina, going to the day in question, again, you're saying this was just too convenient of an explanation.
Doesn't make any sense. If true, how did she die? Right? If they had water bottles, If they had access and they could have come back inside, she shouldn't be dead. So the fact that her daughter is deceased is very strong evidence that what she said she did not do. And let's even believe her. Let's say, okay, the girls could have taken care of themselves. They could have gotten water. They could have come back in. This isn't something that happened in 5 minutes. We're talking about 3 hours. Why didn't you go out there and check?
I love that you mentioned the timeline because I think this is where it did it in for the defense. And again, this is according to reporting from OA Online. So the first responders testified that when they showed up on scene, Jaylin was in a state of rigor mortis. And the forensic pathologist testified that she even got sunburned after she died, that she was starting to decompose. And even, and I'm sorry to say this, some of her skin had come off. Now on cross-examination, Ashley was questioned about her timeline, questioning if Jaylin died and was in rigor mortis all within 45 minutes. Does that make sense? Suggesting maybe all of this was longer. And apparently on body cam video, Ashley also admitted to an officer that she said Jaylin was death rolling with the dogs, meaning she was maybe watching her die from dehydration. I mean, the prosecutor, William Prasher, told the jury she saw that little girl dying in agony in that yard, and what did she do? She turned around and walked away. So the physical evidence here, Florina, right, establishes that the timeline given by the defense didn't make sense.
Yeah, absolutely. This is a parent, a guardian, somebody, an adult, someone who's responsible for this poor child's well-being and health. And instead of taking care of them, instead of doing the bare minimum that is basic common sense, she chose instead to make this child suffer until she died. It's just from the facts clear. You know, sometimes a child tragically dies by drowning in a pool. That's something that can happen in like a few seconds. A parent turns away, the kid falls in, they drown, they die. This child was literally cooked to death in the sun. This is not something that takes a minute. This is something that took hours to happen. She allowed this to happen, and arguably, and in fact, according to the jury's verdict, she wanted this to happen. Because you need to want this to not happen for it to not happen. You need to take affirmative steps to prevent this from happening. So by not doing that, you wanted this to happen. This isn't a shock. This isn't a surprise. Common sense is it's going to happen. It's going to be inevitable that this will happen unless you prevent it. This isn't that much different than a parent who leaves their child in a vehicle in a parking lot. People leave their infants in a car seat. And with that, we're talking about like 10, 15 minutes, and the poor infant cooks to death, literally. Often they're charged with manslaughter because that's reckless. They didn't mean to kill their child. But now imagine leaving that child knowing that the child is in the car seat and purposefully locking that car and leaving the child for 3 hours. That becomes intentional murder.
I mean, it took this jury reportedly 3.5 hours to come back with a verdict here, which is relatively quick. And look, after hearing this, so now does it make more sense if he sat apparently through this whole trial, Daniel, does it make sense that he didn't want to go to trial, that he possibly could have been convicted of murder?
Right. Manslaughter is a one-step reduction from murder. He got 18 years, which is a significant sentence for manslaughter, but it's less than what we typically see on a murder conviction. And so he was able to shave some years off and shave himself from what appeared to him based on her trial to be an inevitable conviction. As a defense attorney, I would say this. I evaluate essentially a cost-benefit, a risk analysis. And having seen a co-defendant in a separate trial lose their case, that is a great opportunity to learn what the prosecution did right and what the defense did wrong and where the jury landed to perhaps run the second trial differently and perhaps get a not guilty verdict. But ultimately, that's a choice the client has to make. And the client just saw that she was convicted and reasonably is now afraid that he's going to be convicted. And I'm sure him and his attorney evaluated the risks and the benefits. And he thought, you know what? A manslaughter is a much better end result than a possible conviction and a sentence that's going to be significantly more on murder.
And by the way, as I mentioned, so Daniel, Ashley, they weren't even these girls' parents, they were their guardians. And according to People, the girl's biological mother, Alicia Anderton, was trying to get access to her daughters, was in a apparent custody fight with the pair. And Anderton reportedly wrote on Facebook after Jaylin's murder that her funeral was the first time she'd seen her daughter in more than 3 years, posting, "I never got the chance to tell her how hard I was trying to be in her life, and I was so close, but I was too late. And all I can think about is her leaving this world, not knowing how much I love her and how much I wanted her. It's not fair that they got so many memories with her, and all I'm left with is a hole in my heart that's so big that I'm completely numb and empty. Part of my soul has died, and I will never be the same ever again." And in an eerie scene, it was reported by CBS 7 that in the victim impact statements, when Daniel pled guilty and he was being sentenced, they described how he showed no emotion at Jaylin's funeral or even during Ashley's murder trial. Florina, thanks so much for coming on. Difficult case to talk about, but appreciate you taking the time as always, and it's good to see you.
Thank you for having me.
All right, everybody, that's all we have for you right now here on Sidebar. Thank you so much for joining us. And as always, please subscribe on YouTube, Apple Podcasts, Spotify, wherever you should get your podcasts. I'm Jesse Weber. I'll speak to you next time.